Good morning. So today I'm going to speak with you about the Accessibility for Ontarians with Disabilities Act, which is often called AODA, and that's the term I'll use with you today. So I only have 20 minutes, so I'm going to just quickly review, identify all 5 standards, and then go through some of the most important provisions that might apply to your organization. But first I'm going to start with a story. So a few years ago, I was diving with Jean Chrétien's son and another gentleman in the St. Lawrence. And on this dive, there was a really strong current. There was very low visibility. And despite the fact I was a very experienced diver, and that's why Jean Chrétien's son, Hubert, selected me to go diving with him, it was scary because I was used to diving in tropical environments with a lot of visibility and no current. So when we came up from the dive, the other gentleman who we were diving with said, "That's the best thing I've done in 5 years." So now you're wondering, how is this relevant to accessibility? And how is this relevant to the AODA? Well, Hubert Chrétien runs an organization called Freedom at Depth, and his organization trains disabled persons to scuba dive, to become certified scuba divers. And that day, we had taken a quadriplegic scuba diving. We also took 2 paraplegic scuba diving that weekend, as well as another quadriplegic. And the reason why I wanted to start my talk with you today with that story is because I wanted to go in with the framework that most disabilities can be readily accommodated. And Hubert Chrétien does this for a living. I only volunteered for 1 weekend with him. But I just saw the way that he looked at things was, how can I make this accessible for my divers? And this is his passion, and this is what he did. So we had the only flatbed dive boat in Brockville. All the other dive boats wouldn't have been accessible, but the dive boat that he found, all the divers could roll on with wheelchairs if they had a wheelchair. And he always had, he carried a big plank of wood so he can make anything into a ramp. So entering the conversation today into the framework, with the framework that disabilities can all readily be accommodated. So now you're asking, why is accessibility important to me? Well, 1 in 7 Ontarians has a disability currently, and the number is rising as our population ages. More than 50% of the population is affected by disability with someone in their immediate family. And I would say that all of us are going to be affected with disability at some point in our lives, either ourselves, someone in our family, or a close friend. And now it's also important because we have the AODA. So as employers, you have further obligations that are going to apply. So Ontario enacted AODA in 2005 in order to make Ontario disability-free by 2025. So you will see when I discuss various standards that the compliance dates, some of them have already passed, and other compliance dates might not happen until 2021 or sometime before 2025. It's important at this point to just make a quick note on jurisdiction. If you're a federally regulated employer, this won't apply to you, so you can go on your coffee break now. But please don't leave, because it actually might be interesting. The AODA is the first legislation of its type on accessibility in all of Canada, so it's kind of interesting to watch. No other province has similar legislation yet, but some other provinces are making a movement towards possibly developing similar legislation, such as Manitoba. And AODA is unique because it's a proactive legislation rather than reactive, like the human rights legislation that most of us deal with. So how it works is, if your organization is in breach, you will be fined, similar to how you would be fined under the Occupational Health and Safety Act, or fined for a breach of the ESA. But it's not a complainant-driven process. So if a customer or if an employee has a complaint about your accessibility, that would still be a human rights complaint that would go through the HRTO. That wouldn't be addressed through the AODA. So It's also important to note that if there's any conflict of law, the AODA has noted the strongest protection will prevail. So it works in harmony with the human rights legislation, the Human Rights Code, and it works together to create better protection. There are 5 standards. The first, the customer service standard. The second, the employment standard. The third, the information and communication standard. The fourth, transportation standard. And the fifth, the built environment standard. So these standards are enacted by way of regulation under the AODA. Currently, there are 2 regulations. Ontario Regulation 42907 is the customer service standard, and it was the first standard enacted, and compliance states have passed, which I'll discuss shortly. And the second regulation enacted was Ontario Regulation 19111, which is the integrated standard. And what the government did was they incorporated 3 of the 4 remaining standards. So in the integrated standard, the employment standards addressed, the information and communication standards addressed, and the transportation standards addressed. First, I'll quickly discuss the built environment standard. I find that when I talk with clients, sometimes the first question that people ask about AODA is, does this require us to have an automatic door? Does this require us to have ramps or make our old buildings more accessible, which might be a very difficult task? So the answer is, we don't know yet because the built environment standard hasn't been enacted. So we're not quite sure how arduous the requirements will be. However, the Ministry of Community and Social Services website does indicate that the built environment standard will only apply to new construction and to very extensive renovations. So in this case, it gives you some relief to know that your old buildings won't need to be retrofitted. Instead, the standard most likely will apply on a going forward basis to make buildings more accessible, which is far easier to do. Now I'm going to talk about the customer service standard. If you have no clue what I'm talking about, listen up. If you haven't done anything yet, you're going to need to take immediate steps because compliance for public sector organizations was January 1st, 2010, and for private sector organizations, January 1st of this year, 2012. And I find that many clients have a misunderstanding that this customer service standard only applies in retail type settings where you view a customer and a staff, but that's not correct. It's important to know that the provision, it applies to the provision of services to members of the public and other third parties. This is very, very broad, so it includes the provision of service to clients, to customers, to patients. So it governs my relationship with my clients or a doctor's relationship with their patients. And it also applies to the provision of service to members of the public. So this would include service to manufacturers, distributors, the government. So essentially, it would apply likely in some respect to most businesses. And it even applies to third parties acting on behalf of the company. So this could be common, for example, in the construction industry where you have subcontractors and subcontractors acting on behalf of your organization. If this is the case, you need to ensure that those subcontractors have received their trainings. There's a different way to do this. If the subcontractors work for a large organization, their organization might have already done the training, and you might just want to ensure that you have some form of documentation signed off that all the subcontractors working for you have received the training in compliance with the AODA. So don't panic if you haven't done anything yet. It's not too hard to comply. It requires training, it requires that you have a customer service plan, and it requires that you report your progress annually to the ministry. So if you have 20 or more employees, it's a little bit more arduous. You have to put several things in writing. And the training can be done using various methods, including written materials, pamphlets, oral training, or even a video. And in fact, the Ministry of Community and Social Services has about a 20-minute video on their website that you could use, require employees to read and sign off on. And the training focuses on how to communicate with persons with disabilities. And the plan requires that you allow persons with assistive devices and guide dogs inside your premises, which generally goes to common sense and public relations. But now you have to make it in writing. So that's a brief overview of the customer service standard, and if you haven't complied yet, give me a call on Monday morning and I'll help you out. I should also mention that the Ministry of Community and Social Services does have a really good website that has a lot of materials that you can use if you want to look there. So now I'm going to talk about the integrated standard, which includes the employment standard, the information and communication standard, and the transportation standard. My time is limited here, and I don't want Mark to pull me off the stage, so I'm not going to talk about the transportation standard because it's not relevant to most of you here. So the integrated standard applies to public sector and private sector organizations that provide goods and services to the public and other third parties in Ontario and have at least one employee in Ontario. So given that you're here, most of your organizations probably have at least one employee in Ontario. And the compliance dates and the requirements vary depending on the size of your organization and whether or not your organization is public sector. The standard considers a large organization as an organization that has 50 or more employees. And in general, more onerous standards apply to public sector organizations and to larger organizations. Small organizations that are private sector with less than 50 employees, some of the standards won't apply. So integrated standard starts off by some general provisions. And I'm only going to talk about the most noteworthy provision, but I should mention some of these provisions are paperwork heavy, so it's just going to require you to have policies and plans on how your organization is going to implement the integrated standard. And the most noteworthy provision, general provision, is the requirement for your organization to provide human rights training. So this is similar to the customer service standard that also has a training requirement. And I would say it's one of the most onerous requirements of the integrated standard. And it applies to all organizations. So the compliance deadlines are 2014, January 1st, 2014 for large public sector organizations, January 1st, 2015 for small public sector organizations, and large private sector organizations, and January 1st, 2016 for small private sector organizations. So everyone's going to be affected, and the standard doesn't specify what exactly must be included in the training, but we hope, similar to the customer service standard, that the ministry might provide a guide and some materials like they've done for the customer service standard. So now I'm going to talk about the information and communication standard. Generally, rolling compliance dates, most compliance dates haven't yet passed, but there is one pertaining to emergency plans that has already passed. So if your organization has emergency plan that's available to the public, then there is a requirement that's effective immediately that if a person asks for this emergency plan that's available to the public in an accessible format, then your organization must make it available as soon as practicably possible. So my understanding is that it doesn't require you to provide a visually impaired person with a Braille plan, emergency plan, but it just requires you to provide the information in an accessible format, which might be reading it aloud to them. It might be sending it to them in a computer document that's accessible with screen readers, which will allow the person to hear the audio version of the information. So there's no specific route to accessibility, but you just have to make it accessible. So be creative. And then the other provision I'm going to talk to you about in the information and communication standard quickly is websites, because a lot of people ask about this provision. So it only applies to public sector organizations and to large private sector organizations. And any new material posted on your organization's website from January 1st, 2014 onward has to be in an accessible format in compliance to conform with the World Wide Web Consortium Web Content Accessibility Guidelines 2.0 at level AA. I have no clue what that means, but you'll have to make sure that you're in compliance. So any new material posted January 1st, 2014 and onward. And the other important thing to note is by 2021, any material posted from January 1st, 2012 to that date will have to be compliant. So right now, you have to be thinking about this, because if you're doing a big overhaul of your website right now and it's costly, at some point by 2021, it's going to have to be in the accessible format. So it's just something to think about. And now I'm just going to briefly talk about some of the employment standards. So most of them have the same deadline. So large public sector organizations, January 1st, 2014. Small public sector organizations, January 1st, 2015. Large private sector, January 1st, 2016. And small private sector, January 1st, 2017. And so most of them have these rolling compliance dates. Know which one applies to your organization. But I should mention one that takes immediate action is the requirement to have an emergency plan. So if you have an employee in your workplace that has a disability that, that you know about and that will require some assistance in the event of an emergency, you're required to have a plan in place of how this person's going to evacuate, which might include having people assigned to assist the person. So that needs to be done immediately. The other interesting things to note are the recruitment process. You should notify all potential job applicants about the availability of accommodation for an applicant with disabilities. So this is even prior to hiring. And then the other interesting thing is if you have testing or assessments involved in your recruitment process, you have to advise that accommodations can be available in the testing and assessment. So given that the definition of disability under the AODA is the same as the definition of disability under the Human Rights Code, this could potentially apply to someone with a learning disability. And with respect to policies and information, all of your policies and information have to be available to your employees in an accessible format as soon as practically possible after you hire them. And then there's a bunch of other requirements that go to creating more paperwork for you. For example, the requirement to have return to work plans documented. However, this is good practice in general anyway. So those are my highlights of AODA for you. I couldn't go through everything today, but I encourage you to refer to my paper titled Merrier Without Barriers, which has more specific information on all the compliance dates. And when considering AODA, remember most disabilities can be readily accommodated. And this is important for reasons beyond AODA, like the Human Rights Code. And if you have any questions, feel free to contact your regular lawyer at our firm. Thank you.